21st, then 17th. Okay.
After 2 weeks.
20
and 21.
and 21 on the request made by the counsel for the petitioner.
Yes.
Stands deferred to be listed after 2 weeks.
I beg to mention item number 26, Malak.
Yes.
I have taken the consent of the other side. Only the matter may be listed after 2 weeks.
And the request made by the counsel for the petitioner, item 26, matter stands deferred to be listed after 2 weeks.
Right, Your Lordship. Lordship, back to mention item number 2, Your Lordship. Please, yesterday we come to know respond number 2 has been shifted to some other place, Your Lordship. We need some changes in the address. We'll file an application regarding.
You withdraw and file afresh.
Only the address has been changed, Your Lordship. We'll
Alright.
file an IA regarding that.
Petitioner counsel, item 2, submits that certain changes are necessary in the address of respondent. She craves liberty of the court to file an IA. Prayer made is allowed. Relist next week.
Lordship. Obliged, Your Lordship.
Praying for listing this for admission, Lordship. On Monday or Wednesday.
Monday or Wednesday. What is the matter?
His age of retirement should have been 62 years, but they have asked the petitioner to retire at the age of 60 years.
When is he retiring?
Already retired. Lordship.
Already. Let it come on 17th.
Yeah, please. Lordship, I beg to mention item 46 of today's.
46.
Yes, Lordship, here Mr. R. Bhav Pujari, yes, Lordship, he is unwell, Lordship, he has not been able to come. I've informed the other side, Lordship, may fix the matter any date next week, Lordship. It's a matter, Lordship, we can, for your Lordship. By the petitioner.
Item
46, Lordship.
46 on the request made on behalf of the respondent counsel that he is unwell.
Yes, Lordship, he
is indisposed. Matter stands deferred to be listed on 11th.
11. Right.
May I please pay for listing for admission, Lordship. Monday, Lordship.
Monday, what is the matter?
Matter relating to Lordship area salary.
Your salary, why you want it on Monday? When was it last listed? When was it last listed?
17/6, Lordship.
No, let it be on 19th. 19 August.
Please, your Lordship, consent of other side, I beg to mention item of 41, 42 and 43.
41,
42 and 43.
41, 42 and 43. Yes.
One is the.
Huh?
Let it come after one.
Yes.
They want to file an affidavit.
41, 42, 43 is on the submission made by Mr. P.P. Dotto. Matter stands deferred to be listed after 1 week, enabling him to file an affidavit. Mr. A. Bhattacharya, IPS for the red petition.
May paper date.
After 1 week, 20 August.
Orders on Monday.
Contempt case for orders on 17th.
May I please? My lord, I beg to mention two items from Monday relating to transfer and rate payment. Obliged.
Is it filed?
Yes, yes, my lord. File yesterday already numbered also. Obliged.
Right, 29 item. One is.
Item 29 on the request made by the counsel of petitioner stands deferred to be listed after 2 weeks. Interim order, if any, passed earlier, will continue. Mr. A.B.T. Hawk for the.
Item 29.
You are for the petitioner. 29.
Item 29. That's 8 payments.
24th.
Obliged.
Sure, I does not want to proceed with the case.
Heard counsel for the petitioner on the submissions made that the writ petitioner does not wish to press the petition any further. Writ petition stands dismissed on withdrawal.
Liberty may be granted.
With liberty, in interim orders, if any, stands vacated, pending ayes are also dismissed.
Obliged.
Mr. U. P. Upamendu for the respondent. P. Das for yes. Where is the clause?
One lordship.
Hmm?
Kindly print annexure one.
You have to be a little louder. The mic not working. Mic to come going.
Annexure one lordship.
We don't want annexure one, we want where is the agreement? Where is the clause for arbitration? Counsel for the petitioner is permitted to address the court on the next date. Come next week, prepare and come next week.
Be taken after sometime.
No, next week. Item 2 has been adjourned.
Lordship, it's a contempt petition, Your Lordship, arising out of non-compliance of order dated 19/12/2025, Your Lordship.
Page number?
The operating part, Your Lordship, is on page 19, Your Lordship. The order starts from page 17. Paragraph 7, Your Lordship. May I read it? According, without adjudicating individual claims of the petition on merit, this court is inclined to dispose of this petition as agreed by learned counsel for both the parties, and also taking note of their submissions of learned counsel for both parties, and also in view of a letter dated 18/12/2025 issued by Director of Elementary Education, which has been placed before this court today by Mr. Talukdar, by directing the responding authorities to complete the entire process of upgradation of the petitioners from tutors to teachers within a period of 4 months from the date of receipt of the certified copy of the order. And accordingly, we made a representation, which your lordship will find it page 21. Till that, lordship, that has not been complied with.
Third counsel for party which will take steps on the respondent. Respondents by speed post within 1 week. Report.
Yes, Lordship.
Is that report?
It's in seal cover.
Seal cover. Open the seal cover. What is your grievance?
My grievance is, my lord, there is an advertisement to fill up the post of principal of the Radha Madhav College's Silchar. 3 applicants, my lord, submit their application. One person, he has got a post of principal, he has got a job, my lord, in Upper Assam, he has gone, my lord. Remains 2, myself and the respondent number 5. On the day of application, my lord, the respondent 5, my lord, she became 55 years. She's ineligible. The moment the authorities found that she's ineligible, what they have done, they've appointed this lady as the in-charge principal, and they kept pending without processing the selection. 1 year it was continuing. We came before the honorable court.
Where is the advertisement?
Lordship will find, my lord, that's in page number 31.
31. Is there any age limit there?
Yes, yes. Page number 32, may I kindly peruse, my lord. Page number 32, serial number 7, left side, serial number.
55.
Yes, and she became 55, my lord. That's why she found she will not be eligible, my lord. What the authorities management they have done? They appointed her in the post of in-charge principal, my lord. See what they frustrated this one. Then we came before the honorable court with the lordship directed the DHS to take up the issue and find out what has happened. After 1 year of lordship's direction, my lord, they have given this import resolution to me saying, I have submitted 10 publications. 2 are not traceable, my lord. Something absurd. These are peer reviewed. Lordship knows what is peer reviewed, my lord. These has got international standard serial number. It has got, my lord. This is what. And now this flimsy order they passed, my lord, saying it is not traceable, my lord. And on the other hand, what they are doing, they're continuing with this lady, my lord, which is ineligible on the advertisement, my lord. That is the reason that's why dealing, my lord. They're not doing anything. They knew if they complete the process, I'll be selected. That's a small issue only. Since my advertisement issue.
No, you have not issued a final order. Why?
Actually,
You have given an advertisement for selection, you continue to conduct a selection, you don't issue a final order. What is the means? There must be an order to say that none of the candidates are suitable. Why is it not been done?
The college authority will take a call on that. They will.
Who is the college authority? Who represents the college authority?
no, my lord, notice has not gone yet.
And you, who are you representing?
The government.
The government. Are you telling me the government is helpless that a college authority can do anything they want and please, right under your very nose? Is that what you're saying?
Once they forward the name of the candidate who is selected,
Now that you are before the court, the pleadings are available with you. You know what is going on. Is it necessary that the court has to issue a direction to the director to cause an inquiry? What is going on? We'll do that if that's what you want. Heard Mr. M. Nath, learned senior counsel assisted by Mr. Nath. What Nath? Mausam Nath. And Mr. D. Upamanyu, learned standing counsel for the higher education. Appearing for 1 in. The petitioner is aggrieved by the fact that in deference to the advertisement dated. What is the date of the advertisement?
15 to 25.
15 to
25.
25. Published by the Said College, inviting applications for filling up the post of principal
Radha Madhav College.
of the Radha Madhav College.
Silchar.
Silchar. The petitioner is one of the candidates who submitted his candidature. Stop thereafter. It has come to the notice of the information of the petitioner that there were a total of 3 candidates, out of which 1 candidate was appointed as the principal elsewhere, and that left the petitioner and the private respondent stop. It is the submission of the counsel to the petitioner that notwithstanding the advertisement being issued, the selection process being undertaken, no results have been declared, and instead the private respondent, otherwise does not satisfy the criteria, was allowed to take charge as an in-charge principal. Stop. The submission of the counsel to the petitioner that the private respondent has crossed the age of 55 years and which is therefore in conflict with the OM dated 25th of February 2019 whereby there is a cutoff limit of the upper age of 55 years. So therefore, neither the candidature of the petitioner has been rejected, nor a regular principal has been selected. So in a sense, no results have been declared pursuant to the selection process undertaken. And without any declaration, the private respondent has been allowed to charge
From 14/3/25.
from 14/3/2025. So when the matter came up before the court, coordinate bench by order dated 25/6/2026 directed the director
Yes.
higher education
Page number 214.
to submit a report in a seal cover. So this report has been filed, has been submitted. Reflects that the candidature of the petitioner was not considered for reasons mentioned therein. But the report does not highlight as to why the candidature of the private respondent was considered, that too in an in charge capacity, when the advertisement itself was for selection of regular principal. Stop. Let the respondents file a detailed report enclosing it and bringing it on record by way of an affidavit within 2 weeks from today. Stop. Further orders will be passed on the affidavit being filed as directed by the Director Higher Education. Stop. The report must indicate the criteria on the basis of which the private respondent was allowed to charge, and whether the claims of the writ petitioner that the private respondent does not satisfy the upper age limit criteria specified in the OM dated 25/2/2019 should also be specified. Considering the issues involved, issue notice returnable 2 weeks. Mr. D. Upamanyu appears for respondent 1 and 2, steps on the respondent 3, 4, 5 by speed post within 2 working days. Dusty is also permitted to be routed through the registry of the court. The respondent will file the affidavit along with the report, enclosing the report as directed within 2 weeks. Please this matter again on 24th. Will it be 2 weeks? 2 weeks. By 26th.
My lord.
Yes. Extra copies be furnished within the course of the day. Extra copies of the standing council. We only said extra copies. You can do it in physical form, you can do it in virtual form. Choice is yours. We did not invite you to file such a thick petition. Your choice.
My lord, I purpose just in a later when I read it.
Yes.
On the last
Instruction
Our insights, everything.
evaded. 1 week further time.
Yes, sir.
Huh? Counsel for the petitioner, counsel for the, what is this, PTC submits, further 1 week time be granted, complete the instructions. Prayer made is not objected to by the counsel petitioner, release this matter after 1 week.
Awesome.
Yes. Instructions.
From the government education.
Yes. State Council. Instructions were sought for from the State Council as to whether the fund is released by the DC.
Started the principal of my college were called by the DC. And it is also informed to him that we have sent the report to High Court. Don't know. DC called me and he told that he has sent the report.
Now, please get, on the last date, MS Kumar appeared in the matter. Huh? Do you find out why instructions have not come? Oh, why 1 week is necessary? We are only asking you what is the status with regard to the release of the fund. This is coming from DC
Bongaigaon.
Bongaigaon. Release this matter on 12th. 12th. Enabling the State Council to obtain instructions in the matter. Mr. M.U. Mahmood appears for the petition. Yes.
This case leads to drop, my lord. Yeah, I have annexed, earlier he approached the petition honorable court. My lord, I have annexed one order passed by this honorable court in the year 2024 because the high power committee still exists. My lord. I want that order on because the
Yes.
I want that order.
Which
Query
order?
covered.
Which
That
order?
is page 79 and except
You let her examine this.
yes, ma'am.
You examine it. Come back on Wednesday.
Yes.
Matter be relisted on 19th, enabling the council for the secondary elementary education to examine the claims of the petitioner that they are similarly situated and therefore their cases can be disposed of in terms of the order dated 29/5/2024 passed in WPC 2473 of 2024. MSP Levy appeal from the petitioner. Released on 19th.
Matter pertains to payment of area incremental benefit from its date of regulation. Now, this court has passed a order in similar matters. It's a covert matter, my lord. At page 30, one such order.
Those for the respondent.
The elementary education.
Elementary education. Yes, please tell us whether this is covered. Page number 30.
Respondents were directed to
You examine and come back within after some time at the end of the motion list. No. Pray only. Allow her some time to go through.
agreed by Lord non-grant of UGC based scale, Lord, after completion of the his PhD degree. Lord, the college has forwarded the proposal. My lord, the director of
What are you asking for?
Lord, I'm asking for a regular UGC pay scale on, my lord, acquiring the PhD degree. Initially, my lord, I was appointed on fixed pay, and my terms of appointment, my lord, at page 18, required me to my lord, qualify the PhD degree, and on completion of PhD, my lord, I'm entitled to regular UGC scale. My lord, will peruse page 39, annexure D, is the proposal, my lord, which has been sent by the principal of the Saraikhat College. So I may read, my lord.
This is forwarded to the director.
The director.
There is no response from the director.
Director has responded, my lord, at page 40. That is the impugn order, my lord, by which the director has stated, my lord, that I have not acquired the qualification within 2 years from the date of regularization. Hence, my lord, my claim has been rejected. Now, my lord, this issue has been squarely, my lord, covered by judgment, my lord.
The one which you have enclosed?
No, one different.
Why have you enclosed this judgment?
No, that is also, my lord, on the same issue, wherein, my lord, The court has held that if candidate qualifies
Counsel
PhD,
to the parties
Well-
notice and Mr.
It's
S.
a
Das
covered
appears
judgment,
for
Malad.
the higher education representing all the respondents. Therefore, he says the waived extra copies be furnished within the period of 1 week.
well, 100% may take instruction, my lord. It's a covered judgment, my lord. We take it after some time. My lord, 6572, exactly same issue, exactly same.
Yes. Huh?
The same time, Madam,
You agree that this matter is covered?
from the date of acquiring the eligibility.
We are asking you the judgment which he has forwarded, is it covered or not?
It's covered.
It is covered.
And subsequently, subsequently another.
My lord, paragraph 4, 3.1, my lord, will see.
You examine and come back on 19th.
My lord,
Tell
we
us.
take it after some time.
Covered. Right, heard, spoke, covered.
Well, the picture is not a regular, Malad, against the appointment of a team, Malad, as assistant professor appointment. But they have done, Malad. They have violated the Malad UGC guidelines, Malad, right? Appointing. Even Malad results has not been declared TT. Not appointment as an student, he has joined.
This is pursuant to a selection process.
Selection.
Advertisements issued.
It's not.
Yes, Mr. Nair?
No provision of the UGC regulations violated, my lord.
So we'll issue notice at this stage.
Let the final.
Heard Mr. Honecker, learned counsel petitioner, Mr. Nair appearing for the
One.
respondents 1 and 2. Petitioner is aggrieved. Who's for UGC? MS Borpujari for UGC. A Borpujari for UGC. Petitioner is aggrieved by the selection of the private respondent number 3. In what post?
Assistant professor.
Assistant professor.
In Department of Chemistry.
The Department of Chemistry in Cotton College.
Cotton
Cotton University. According to the petitioner, the private respondent does not satisfy the norms prescribed under the UGC, and without adhering to such norms, the appointment has been made, and that too without declaration of results.
Declaration.
Considering the submissions made, issue notice. Since respondents 1, 2, and 4 are represented, furnished within a period of 1 week. Steps on respondent 3 by speed post within 1 week.
Appointment subject to the outcome of the accused. Appointment should be subject to the outcome of the accused.
Issue notice on the interim. Let us see. Returnable on the same date, 28th. 28th. On 9th of September.
Diploma.
Diploma.
May I please, your lordship, this matter pertains to the area salary.
Area salary.
Yes, ma'am. For the
Can you
month-
get instructions?
This is the first time.
Yes, we have seen the notice, heard council for parties issued notice later weeks. MSP Das, standing council appears.
2, 3, and 4. Second.
Why state of Assam is
Silence is there, your
made
lordship.
respondent twice?
1.
1 and 2 are state of Assam.
Department of Finance.
Huh? Respondent, she represents respondent number
By commissioner.
3, 4. Anyone for finance? Borua for finance. Then the respondents are represented. Next copy furnished within a period of 1 week. Yes.
Obliged.
I'm deeply obliged.
Well, mostly here, Yoga University is from copy was not served to us.
Because no one accepted the copy. We tried to serve. That's my instruction. Anyway, we'll serve you a copy.
You're a standing counsel.
Otherwise, my lord, the matter is very, I can give a copy just right now.
What are you praying for? Pension.
My lord, area pension law of father, my lord, which is
Heard.
Notice may go, I am not.
page 53, my lord. Page 53 is the amount, my lord, which they calculated in the earlier repetition, my lord. That was filed with the association. Page 20, my lord, serial number
No,
201.
we'll issue notice for
No,
the
notice,
heard.
no.
Mr. M. Dotto, Senior Counsel, assisted by Mr. Bonso. Issue notice, returnable for week, Mr. K. Gugoi appears on behalf of all. One
follows
to-
you.
1 to
1
5.
to 5 lots.
And the K. Fukon for respondent number 6. Since the respondent, the representative notices are waived, extra copies will be furnished within a period of 1 week.
But our name may be.
Names of all
Yes,
standing
Yoga
counsel
University.
will be reflected in the course list by the registry.
Pendency may not be a bar.
Tendency of the writ petition may not be a bar for release of the arrear pension
Area.
but this is pertaining to the writ petitioner's late father.
Yes. Diploma.
Please, your lordship. Item 13 and 14, both are same ballot,
Same
but the
matter,
amount
amount is different,
amount
your
is
lordship.
different and that is
13 and 14. They should notice. This is area salary.
yes.
All right, heard. Same.
The form of
This
MSCB.
is connected to the which matter? 11.
Uh,
We should notice in one matter. Which matter is that?
11, then this matter and
13.
13. 13 and 14. Same.
11, 13 and 14.
Yes. Amount is different. Different.
Service, my lord. Serving as my craft teacher, and her name was duly recommended, but thereafter not progressed. The earlier act also stood down, my lord. And the subsequent act also stood down.
Heard. Counsel for parties issue notice written in weeks. It's N.M. Sharma appears for respondent.
1, 3 and
4. 1, 3, 4. M.S. M. Barua for respondent number 2. Mr. J. Uloskar appears for respondent number 5. Since the respondent, the represented notices are waived, extra copies furnished within 1 week. Release this matter again after the returnable date.
In this case, petitioners applied for registration of as pharmacist. His application not considered. After completion, he says he duly pursued the pharmacy diploma. Then, interns also completed, and after completion of all procedure, he applied. But his application not considered by saying that he is failed in PCB physics. The similar, otherwise he passed, he says, but physics is failed, my lord. In the similar case, my lord, court has been decided, my lord, and directed the concerned authority to duly register the petition. And that order I have annexed here with as annexure 4, page 22. Similar case.
Yes, madam. Heard. Counsel for parties issue. Or would you like to examine it and come back next week? Will not issue notice. Heard. Counsel for parties issue
East National
notice. Returnable 2 weeks. MSD Bora, then counsel represents the health department, representing respondent 1, 2, and 3. Steps on respondent. Therefore, extra notices, no formal notice need be issued. Extra copies will be furnished within 1 week from today. Steps on respondent 4 by speed post within 3 working days. Matter be listed after the returnable date. Then it can't be 2 weeks because the respondent 4 is in Bangalore. It will take at least 4 weeks. Matter be listed after 4 weeks.
Inspection may go for they get similar set of
They want notice. We asking them, they are not willing to accept. come back with instructions, therefore. You have to wait until the returnable date.
Until
Yes.
Well, having this regarding the discontinuation of the dashboard of the petitioner's discussion. The dashboard was allotted to the petitioner in the year 2007, and subsequently, due to the non-submission of the report by the concerned CRCC in time, the DICE was discontinued. Then the petitioner applied before the director of second.
Discontinued and allotted to some other school.
No, then applied, and then the director given a direction to the district commissioner to hold a meeting, and accordingly, DLC meeting was held.
Why? All right.
Accordingly, the DLC meeting was held on 17/10/2025. In that meeting, my lord, the direction was given to the petitioner to apply in the EODB portal, an online portal, and subsequently the petitioner applied for that. But the same has not been allotted. Again, he filed a representation. Then a final inquiry report has been made. It is page 43. It will be clear. Page 43. That inquiry report submitted on 16 June 2026. Recently. Yes.
Council appearing for the secondary elementary appears for respondent number 378. MSK Fupan for respondent number 5. For 6. District mission. MS for respondent number 1 and 2. So who's for this?
Well, SSA Mr. Asborough earlier appeared.
Who's this counsel for SSA? Asborough appears for respondent number 6, 4 and 6. The respondent, the representative, waive the extra copy. Release the method again.
And my lord, the petitioner is a music teacher, my lord, which is covered by the judgment of Honorable Apex Court, case number 89. My lord, the judgment of Apex Court starts.
Music teacher.
Yes, sir. The mandamus is at page number 106. 107.
Yes, Mr.
Notice maybe because he is seeking provincialization on 2011 Act.
My lord, we are included in the list of 240.
Alright, Mr.
214, my
Mr.
lord.
S. Das. U. Sharma appears for secondary education. He appears for 1, 2. M. Borua for respondent 7, A. Fupan for respondent number 3, and 6, since the respondents are represented. This is a waive. The respondents 1, 2, 3, 4, 6, 7, 8 are represented. Notices a waive. Extra copy will be filed within a period of 1 week. Okay. Steps on respondent number 5 by speed post within 1 week. Released after the returnable date.
My lord, it may be connected with similar pending matter. My lord,
After returnable date. Let it come after returnable date. You take steps, complete, let the notice be issued, then we'll connect it.
Pendency shall not be barred because already Supreme Court has
Pendency shall not be a bar to resolve the grievances of
in the light of
redress
that.
by the redressal of the grievances.
Yeah. The petitioners before your lordship, the assistant professor of science college. At this moment, also I'm praying for notice. What we seek are here seeking notional benefits of the past services which has been given by them under the career advancement scheme.
Third, council for parties. Steps on respondents by Mr. P.C. Musari, case for respondent number
3, 4, 5 and 6.
3, 4, 5 and 6. Mr. S. Das for 1 and 2. You are for higher education? Mr. Das for higher education? For respond 1 and 2, since the respondent the represent within a period of 1 week.
Our name may be so.
Names of all standing council will be reflected in the course of this material.
I'm already.
Attends to compulsory appointment, my lord. Here you challenge the speaking order. So I page 251, my lord.
State has already stopped compassionate appointment. Why are you
My lord,
insisting?
the speaking order there we have challenged. My lord, here, my lord, it was rejected on the ground of, my lord, lapse of time, my lord. Here I have
Heard
annexed
MS
one judgment, my lord, where I have realized.
Counsel for the petitioner issue notice return over 4 weeks. MS K. Fugan appears for respondent number 1, 4, 5, 6, and 10. The MS S. Sutia appears for respondent number 2 and 3. 7, 8, 9. The respondent being represented, waive extra copy furnished within the period. Released after concluding. Recorded.
May I please, Lord. But the matter pertains to cancellation of prior permission and provisional registration, my lord, of the petitioner school.
Get instructions.
But my lord,
Heard the PM Degal and petitioners are agreed by the cancellation of provisional registration of the school allotted by the respondent authorities on the ground that the required infrastructure could not be made available as required under the terms of the registration and the rules thereunder. Stop Mr. Dekka submits that the reason for delay is beyond their control. They have explained everything in the reply which was filed before the authorities. However, without considering the hardship faced, the impugned order has been. Where is that order?
my lord, at page 58.
Order has been issued cancelling the registration by the director. Having heard learned counsel for the parties, will you be able to get instructions?
He said no, please, a short date mechanism.
My lord, my
Notice returnable
2 weeks.
2 weeks. Mr. SMT Chisti appears for
1, 2, and 3.
1, 2, and 3. And Mr. Roy for 4 and 5. The respondent, the representative, no comments. However, extra copies be furnished within a period of 1 week from today. Matter be made returnable on 28th
Yes, sir.
of August.
Yes.
If the next returnable date, impugned order dated so and so shall remain stated.
my lord, till then, my lord, that the order may be stayed, my lord. Otherwise, the more
That
than
will-
500 students are there, my lord.
Then lost may can give a 1 week time with
My lord, Monday there is my lord, Monday there is a test, my lord.
Yes.
Otherwise, they couldn't help it.
that school doesn't have any public recognition loss. How can that be continued loss?
Issue notice on the interim prayer. Returnable on 21st.
Yes.
My lord,
21st.
the whole stakeholders will be prejudiced, my lord.
Date. And so shall remain state.
My lord, till then, my lord, interim may be passed, my lord. That may be stayed, my lord. Otherwise, my lord, from Monday, the school, the students cannot come, my lord. Already that has been cancelled, my lord.
They've already passed till 21st.
Much obliged.
Here. We are making returnable on 21st for the interim. Till then, stay.
Much obliged.
Yes.
Yes.
Similar. Where is that order?
Page 30.
30.
Right.
The council for parties disposed, subject to verification. Yes.
Public.
None appears for the petitioner, MS NM Sharma for the respondents. That will be listed after a week. Yes, affidavit. None appears for the petitioner. MSS Suti appears for the respondents. That will be listed after 1 week. MSK for the state respondents. Yes.
Yes, his speaking order has been passed by the mayor.
Give him a copy also. What is the direction of the court? Page number?
Page 12.
What was your prayer in the writ petition?
Kind of para 4 of the order, man. Para 4 here, all these cases are regarding authorized.
What was your prayer in the writ petition?
Let me see it. Kindly ask for time.
Mr. Bora, please see para 7 of
Well,
the.
yes, my lord, but kindly see para 4 of the order, my lord. Here, my lord, is submitted by the learned counsel for the petitioners that the government of Assam has issued a corrigendum dated 2021 in the Assam Gazette, removing the requirement of passing the required education qualification before attaining the age of 40. Therefore, the appointment order may be issued to the petitioner if they are found to be qualified otherwise. The learned counsel for the councils also submitted in the similar cases. Application number 1. This court has directed consideration of the appointment of the petitioner. Well,
we are closing it.
Let my
That order has been passed. Boy, what is the necessity of your senior to be present here?
I'll just provide him this.
Call him after some time.
And in this case, I may be allowed 2 weeks time to take the update instruction. Because since long time, my lord, I could not contact with the petitioner, and the matter was earlier referred to the mediation, but the mediation also failed. He did not appear, my lord.
He did not appear, we dismiss it.
No, my
Leaving
lord,
it open for him to pursue it as and when he decides. Why should we defer the matter like this? We are sent to mediation, he refused to appear in mediation, you are not in touch. Why are you keeping this matter alive?
Just a 1 week, Malad, I will take the instruction.
On the request of the counsel for the petitioner, matter stands deferred to be listed next week,
Much.
19th. MS N.M. Sharma for respondents.
Seven, I think little accommodation because the A coupon, he has filed a affidavit against the appeared. The recorder, because of his illness, he is unable to come. And I think by next Friday, we get it fixed. By the time I have checked, he has filed an affidavit also. Additional affidavit also.
Mr. SMT Chisti submits that the Mr. A. Fukon, counsel appearing for the respondents, had filed the affidavit. However, he is indisposed, therefore submits that matter be listed after a week.
Yes.
Release this matter again on 19th.
Last order of the
Yes.
Here we have filed our appeal, not yet listed, my.
You have filed it.
Filed.
That submission.
Mr. M. Khan, have you received a copy?
No, Lordship, that
10 days time may be granted, man.
You have filed or you are willing
Already
to
filed, man.
file?
Filed.
When did you file it?
NJ Khatunia has filed. He has informed that already filed it, man.
and that I have learned that it was filed in the.
How can you file it without serving copy on the other side? Where is Mr. Khatun? Call him. Call him.
I'll take it.
If you have filed it, copy should be served to the petitioner. Please inform.
Well.
After some time.
Kindly allow me to read something out file.
Hmm?
I don't have file.
You don't have file.
Yes.
It's taken away by the petitioner counsel.
Yes. I may be allowed to read one.
All right. Why have you taken away the file? Counsel for the PTC, Mr. P.C. Mushari, submits that he be permitted 2 weeks' time to reconstruct the case record as the same have been misplaced or are not traceable. Mr. Ms. K. Devi, learned counsel, appears for the petitioner, does not object. Release this matter again after 2 weeks on 26th of
Master
August.
Yes.
Wait, please, the lordship.
Lordship, in this case, we have sent the affidavit for vetting and 1 week time. Affidavit has been sent for vetting.
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 Mr. P.P. Dotto, counsel appearing for higher education,
Secondary.
secondary education, submits that the affidavit will be filed when?
Only 1 week. Next week.
He submits that the affidavit will be filed next week, within 1 week. He submits that the matter be listed thereafter. Prayer made is not objected to by Mr. R. Sinha, counsel for the petitioner. Release this matter again after 1 week. 21st.
Your lordship, my only prayer is that let him file prior to 21st.
Yes,
The respondents will ensure the affidavit is filed before the next date of listing.
I'm deeply obliged. Grateful.
Reason, my lord, the prayer was made from the to file an affidavit. I need some time, my lord. My lord, here actually director.
Further 2 weeks'
to pass
time
an order.
permitted to the respondents to file their affidavit. Mr. R. Deka appears for the writ petitioner. RM Deka appears for the writ petitioner. Released again after 2 weeks.
May you prefer date, my lord?
28th of August.
My lord. Deep law.
Consent letter is,
Received
yes, Lordship.
in deference to the earlier order dated 19/6/2026. Justice Vasudev Agarwal, former judge of the Gauhati High Court, was appointed as a sole arbitrator to decide and arbitrate on the disputes arising by and between the parties, subject to filing of a written declaration as required under Section 12(1) of the Arbitration and Conciliation Act. So, Justice Agarwal has filed a written declaration expressing no difficulty or hardship in acting as the sole arbitrator if appointed by the court. Same is available in the case record. So, that view of the matter, the appointment of Justice P.D. Agarwal, former judge of the Gauhati High Court, stands confirmed. Appointment of so and so made by the order dated 19/6/2026 stands confirmed. So, Mr. P.D. Agarwal former judge of the Gauhati High Court, will be the sole arbitrator to decide and arbitrate on the disputes arising by and between the parties relating to the differences arising respect of contract agreement number so and so, dated so and so. The parties, the registry will communicate a copy of this order, Justice B.D. Agarwal. Parties will appear before the learned arbitrator appointed on
Up 3 weeks.
28th of August.
It took some time.
Many times has been taken up, my lord.
Regarding
And from
area
2023, not area, my current salary also hold, my lord. From 2023, I have not received any salary, my lord. And for filing affidavit, my lord, many times has been taken up.
Submit proposal.
Then my lord, current salary may be released, my lord. Because my current salary also not released, my lord. Let them to decide the area salary, and my lord, current salary may be released, my lord. I am without salary.
Why is it not being released?
But there are earlier litigations, my lord.
There are some
There are some.
litigation. There was
No, but where is the stay?
No, presently no stay, my lord, because that litigation has already been disposed of without interfering my provincialization, my lord.
You want to file affidavit or what?
one thing.
When do you want to file it? No, not 3 weeks. Not 3 weeks. We give you 2 weeks. Failing which we will direct personal appearance of the officers who are responsible for not filing it. We have given you sufficient time to file. Learned counsel appearing for elementary education is permitted 2 weeks further time to complete instructions and file affidavit. We've seen that several opportunities were earlier granted to file the affidavit, but no affidavit has yet been filed. The petitioner is agreeing that the area salary as well as the current salary has not been released, in spite of the petitioner continuously serving as a teacher as a tutor
Tutor, my lord.
in Paschim Moiradhad ME Madrasa.
Now
Where are
I
you
am serving at Moiradas LP school.
Moiradhad LP School. is made clear if the affidavit is not filed, the court may issue consequential orders against the officers who are responsible for the delay in filing the affidavit. Released after 2 weeks. 28th, 26th of August.
Hello.
It's for appointment of the arbitrator. On the last occasion, the lordship was pleased to issue notice.
Any objections? Steps completed, notices served.
Yes, my lord. There is only one respondent. That is the Assam State Rural Livelihoods Mission.
Someone has entered appearances.
Framework of the memorandum, I am now invoking the arbitration clause. But my lord, on the other hand, they have already issued a blacklisting order, which is of course a different cause of action, which I have since assailed before this honorable court and is listed today before the condemned bench.
Where is the agreement here?
Yes, my lord, will see the agreement is at page number 15 onwards, annexure 1. This is the memorandum of understanding that was executed on 29th of February 2020. So we were the nodal agency under the Deen Dayal Upadhyaya scheme. So the project ensued and we were supposed to extend the training and the placement of rural youths.
We'll call up the matter again at 2 p.m.
2 p.m.
Let the other side appear. Meeting. Second, at 2 p.m.
The thing is that the BSA has submitted the family concern proposal and all relevant documents to the director of concern matter. Now it is pending on director of concern.
None appears for the petitioner. Mr. Das. Sharma appears for the respondent. Secondary education, Mr. Pegu for
Director of Pension.
Directorate of Pension, and M. Sharma for A. Sharma for Accountant General, M. Barua for Finance. Released after 1 week.
May it please your lordship. I am under suspension for a period of 1 year, 20 days.
Proceedings.
Your lordship, the disciplinary proceedings have started. It is not initiated, in fact, in that manner. They have served me with the memorandum of charges and they've reviewed my suspension orders. Can I place the suspension orders to your lordship? Although those were placed before this.
Why
No.
suspension for so long?
Your lordship, the suspension, they have reviewed it. But there was a violation of the judgment passed by the Honorable Apex Court in Ajay Chaudhary. The direction given there in the second part that there has to be a review with a reasoned order. Of course, there has been a review, but without any reasoned order.
Where is the order of suspension?
Your lordship, the order of suspension is at page 25.
Then where is
Now-
the order of review?
Now, your lordship, the order of review is not there. After the filing of the case, they came up with the order of the review. They have presented it before the court and they have also given me the copy. If I may place this, your lordship, the show cause notice was of 4/10/2025, that is at page 29. And the show cause was furnished to me on 9/10/2025.
Here, the most important fact is that when the show cause notice was served upon me, no review order was served to me. And most importantly,
Review after 90 days.
no, review was within 90 days.
Within 90 days.
There was no doubt about that. But at the time of submission of the show cause notice, they have not submitted me the review order. And thereafter also,
What are you challenging here?
Your Lordship, I am challenging the suspension order on the ground that although review has been made, but that review has been undertaken without any reason order.
Where is that review order?
Yes, Your Lordship, I mean.
Why bring it on record? Why you?
Your Lordship, it is not given to me. They were placed before the court, Your Lordship,
So you
on the
bring it
last
on
occasion.
record.
Your
What is
Lordship,
that review order?
this is the first review order, Your Lordship. If Your Lordship comes to 1, 2, 3, 4, 5, 6th para, and whereas the committee, after careful examination of the records and consideration of the gravity of the charges,
Then
and
before that,
Your Lordship,
before that.
and whereas the suspension
No,
review
before that.
and whereas as per the provision of Rule 61A,
You are reading this 17.7. This is the order of suspension. Where is the order of review?
it is the next page, Your Lordship. Your Lordship, this is the bunch of the review orders I have just placed before Your Lordship right now.
They have given the reasons after examining the records, considering gravity of charges. This is the reason.
No, Your Lordship, what is the reason order? There is no reason order, Your Lordship. As per Ajay Chaudhary, there has to be reason order.
Reasons, sufficiency of reason is something else. Reason order is where there are reasons. This is the reason.
This is not
You may disagree with the sufficiency of reasons.
Your Lordship, in my
Can you
humble
say
submission-
there are no reasons?
Your Lordship, when an administrative order,
This is the reason. The reason is that after careful examination of records and gravity of charges, this is the reason. You may challenge it that this is not the correct reason, incorrect, not sufficient reason. But can you say there are no reasons?
in my humble submission, Your Lordship, as per the Ajay Chaudhary's direction and the
Let
subsequent...
us see Ajay Chaudhary direction again.
Yes, sir.
Yes.
If I may draw Your Lordship's attention to para 21.
Yes.
We therefore direct that the currency of suspension order should not extend beyond the 3 months if within this period the memorandum of charges is not served on the delinquent officer employee. If the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension.
This is the
As
reason
in-
order.
No, Your Lordship, the reason is that they say that the gravity of the charges. What gravity of the charges? Your Lordship will
You
kindly
show
come
us
to
that, you show us what is the definition of a reason order.
Your Lordship will kindly see the suspension order once again, Your Lordship.
You say there are no reason. Lack of reasons would be that they have passed something without any understanding of how the order has been passed. They've given some reasons.
This is the gravity of the
According
charges.
to
Is it enough, Your Lordship? It is not enough. In my humble submission, that is not enough, Your Lordship, to
That
say.
may not be enough is a different issue.
Your
But can
Lordship.
it be said that this is not a reasoned order?
Yes, Your Lordship. In my humble submission, I'll demonstrate.
Satisfy us
Yes,
that
Your
it is
Lordship.
not a reasoned order.
Yes, Your Lordship. Your Lordship, this is the suspension orders, and thereafter they have served me the show cause notice. Now the show cause notice is at page 29.
Yes. Show cause notice was issued when?
Show cause notice was served upon me on 9/10/2025.
Is it within 3 months?
Yes, Your Lordship, it is within 3 months.
Right.
But at the time of serving the show cause notice, they have not served me the review. That is, later on they have served me, but of course within 90 days period, Your Lordship. Now, number one, Your Lordship, violation of Rule 3 of Assam Service Conduct Rules 1985, violation of Rule 9 of the Assam Services Conduct Rules 1985, fraudulent withdrawal of allowances, financial irregularities, breach of institutional discipline and security, administrative
You are
misconduct.
challenging the show cause also.
I'm challenging the suspension order and non-furnishing of the substantive allowance. Your
Not
Lordship.
the show cause.
Your Lordship, I'm not challenging the show cause. What I'm trying to say is that
Yeah.
these charges are grave. So if the charges are grave, there has been no FIR, no arrest, nothing, Your Lordship. Simply they say that they want to extend my review. Extend my suspension period.
That's right.
For what reason, Your Lordship? They have not came up with any reasons. They say the gravity of the charges. If the gravity of the charges are that,
So if they have to give you all the reasons, what is the point
No.
in initiating a show cause? It's the show cause which will give you whether the charges against you are satisfied, supported by evidence or not. As on date, they say that there are grave charges against you. You can't be reinstated. They have initiated the proceedings against you. You may seek an order from the court to expedite
Your
the
Lordship,
proceedings.
in that case, what is the reason order? In that case, I would like to place a judgment, Your Lordship.
Yes, please. What is the stage of inquiry?
It was done by the director of HCRT Lordship, with the HCRT council.
Then why are you sending up? Who's the NCRT council?
It's coming.
Huh?
It's coming, Lordship. I got
You have given him an invitation.
it. Lordship.
Very nice. Are you representing NCRT or not? So don't submit. Please request the presence of the NCRT council. Yes.
Lordship, I will place one judgment pro forma.
That is not a service matter. That is an excise matter. How are you comparing an excise matter with a
In
extension
that
of?
case, Your Lordship, the judgment was like this, Your Lordship. If I may just place it. Para 38 onwards, Your Lordship. Ajay Chaudhary was relied on that.
Para 30.
38.
38.
Therefore, from reading of a paragraph number 21 of the judgment in case of Ajay Kumar Chaudhary's, Rafid Ali Ahmed, as well as the office memorandum dated 4/2/2020, as noted above, would clearly show that the right of reinstatement accrues upon the delinquent officers upon completion of 3 months from the date of the order of suspension or the date on which the delinquent officer gives notice to the appointing authority, discipline authority, that the delinquent officer has been released on bail or is on otherwise custody or imprisonment if no memorandum of charge sheet has been served upon him or her. However, though the right accrues, but there is a necessity that the right also has to be exercised by giving notice to the discipline authority, appointing authority that a period of 3 months has elapsed from the date of the order of the suspension of the date on the delinquent officer had put to notice the appointing authority. Disciplinary authority that she has been released on bail or is otherwise in custody or imprisonment and no memorandum of charge have been served upon him. The appointing authority, discipline authorities, upon such notice being issued by the delinquent officer, is required to reinstate the delinquent officer in view of the law laid down by the Supreme Court in Ajay Kumar Chaudhary, as well as the court in such and such judgment. Apart from that, a clear mandate in the office memorandum dated 4/2020, the inaction of the discipline authority, appointing authority to reinstate the delinquent officer upon such notice would render their action in contravention to the law and the law laid down by the Supreme Court in Ajay Kumar Chaudhary's, as well as the other court in Rafid Ali, which would in turn render their action subject to the judicial
What
review.
notice is referred here?
Your Lordship, the notice is referred as a notice to the discipline authority.
By whom?
By them, that a charges has been initiated against me. Now, if your lordships kindly come to page para 42, the next question which arises for consideration is in respect to the second part of the declaration by the Supreme Court in the case of Ajay Kumar Chaudhary Supra, to the effect the memorandum of charge sheet is served a reasoned order must be passed for extension of the suspension. Therefore, it is in the opinion of the court that at the time of or immediately upon the memorandum of charges, charge sheet is served, the disciplinary authority is also required to apply its mind as regards the necessity to continue the suspension or not. In such circumstances, the disciplinary authority is required to pass a reasoned order as to why the suspension of the delinquent employee is to be continued. Now, from reading of these review orders, it does not seem that they have applied their mind. And if your lordship looks the other review orders, it's a cyclo style, your lordship.
From where does it say what is the, how much of reason is necessary to satisfy the rigors of reasoned order?
Your lordship will
It may not be palatable to you. That should not be a ground to say that it is not a reasoned order.
But that cannot be a ground to say that his suspension is required. Simply saying that would not serve the purpose.
That you challenge the reasoned order, that these reasoned orders are not valid or whatever it is not under challenge.
Your lordship, that is subsequent to the filing of the writ petition.
Whatever, that unless you put a challenge to the reasoned order, to say that it is not a reasoned order.
Your lordship will appreciate
Therefore,
the fact that the suspension is not a punishment. It is only required to see that the investigation
the whole difficulty is that you have not referred to the rules. The power to suspend you comes from the rules. Have you seen the rules?
Yes, your lordship.
Have you seen the rules?
Yes, your lordship.
Please show us the rules.
Rule 6, your lordship, the Assam disciplinary appeal.
Yes, tell us.
Rule 6, your lordship. It will be under 6.1, your lordship. The appointing authority or any other authority to which it is subordinate or any other authority empowered by the governor in that behalf may place a government servant under suspension where a disciplinary proceeding against him is contemplated or is pending.
This is number 1.
Yes, your lordship.
So contemplation or pending.
Right,
is sufficient to place you under suspension.
Right, your lordship. But in now this has to be read in consonance with the direction passed in the Ajay Chaudhary's judgment, which has been
not in the opinion of this court, because Ajay Chaudhary did not consider these rules. The power of the authorities flow from the rules. These rules were never considered before Ajay Chaudhary. Ajay Chaudhary is the applicability of the principle is generally the 90 days you should proceed. But you read Rule 6, it has got 3 parts.
Your lordship, there is a second part also. Not only 90 days, your lordship, I agree to that. Second part is that a reason order is beyond 90 days. Now, my humble submission before the honorable court is that
show us from Rule 6 where these provisions are there.
No, this provision is not there.
Not there. But have you challenged the rules?
No.
That in view of these judgments of the Supreme Court, these rules should be amended. You want to read Ajay Chaudhary into these rules.
Back in terms of the Ajay Chaudhary judgment, the state has also enacted a memorandum. And
State did not enact a memorandum pursuant to Ajay Chaudhary. It is pursuant to a
judgment.
Coordinate bench.
Right, your lordship. Judgment.
Right.
But that has been referred. So now they have to abide by their own guidelines,
that's right,
which they are not doing.
Does it lay down the extent of reasoned order there in the memorandum?
Your lordship, in that case, your lordship.
In fact, we are with you that yes, according to you, this may not be happily worded. But can you say that this is not a reasoned order?
Yes,
there is a reason, even half a sentence is the reason, could be a reason.
Your lordship, the day when I was suspended, there was a reason. They are carrying that particular reason in a cyclo-style word.
To say that these reasons are not made out on the records. This is not under challenge. Unless you challenge it, unless you confront the respondents with this challenge that these are not germane to the reason for extension of suspension, they are entitled to be given an opportunity to respond.
Your lordship, in fact, the lordship goes to the others review orders which has been passed subsequently. Same cyclo-style order. In the humble submission, that cannot stand the scrutiny of law. If that be the case,
nobody is stopping you from challenging it. You're not bringing it, you're not assailing it. You're barely saying that your suspension is bad, but otherwise they have complied with the review. They have complied with issuance of the show cause notice. You are not challenging the proceedings, that these proceedings are not maintainable for whatever reason.
Your lordship will, in that case, your lordship will give me some time.
We are closing this, giving you liberty if you want to challenge. Your primary challenge is not there now. Yes, Mr. Nayak? You disagree?
Yes, doctor. Already speaking order has been, written order has been passed.
No, we asked you whether you disagree with the views of the court.
No. Let him challenge that order. Doctor, even if we go, go by the other children, therein also, in paragraph 22, court advised the petitioner.
But he can always make an amendment if he wants. Why should we foreclose that option? Give you 2 weeks time.
Your lordship, in the meantime, your lordship will direct them to release my substantive allowance because I
That has already been released. That order is, he himself annexed.
On the request of the counsel for the petitioner, matter stands deferred to be listed after, enabling him to complete his instructions, whether he'd like to further file an application seeking amendment. It is further directed that any subsistence allowance payable to the petitioner, if not paid.
Already there, order
If not paid,
on
will be
the
released.
next 75%.
Annexed where?
In the bid petition, it's
And then why are you praying again?
page 40.
it's paid, your lordship.
Huh?
It's paid, your
Then
lordship.
why are you asking for substitute?
I'm sorry.
Again, after 2 weeks,
Deeply obliged.
Mr. P. Nayak, you are appearing for NCRT. SCRT. Additional AG appears for SCRT.
I'm obliged, lordship has taken such a view.
Huh?
It's very rare. Others already
No, I'm taking a view because nobody else is taking a view.
Yes,
What can be done unless you urge the matter? How we are not here to lay
because
down the law.
Our High Court is the only High Court, I think, lordship. So much hype has been created by this judgment. Others, lordship has already.
I am
already
entitled
lodged.
to
At
take
least
a
7
view.
judgments
My
of
view
different
may
High
not
Courts
be
I can
correct,
take.
maybe it's a different issue. But this is my view that perhaps this judgment has not laid down any universal proposal. Yes, the safety requirements are there within 90 days to it. You have also issued a office memorandum which can be understood that till the rules are amended, this will follow. Follow the ON.
This case has already.
Yeah.
Applied.
In this case, everything has been during the course of the.
They are filing it today.
Already is coming.
M. Sharma, Council. PP Dr. Hearing. Secondary education submits that an affidavit by the use of the day. So, release this matter after 3 weeks, 2 weeks, enabling the petitioner to file rejoinder affidavit if so advised.
In item 39, my lord, there was an order passed at page 72. We directed to obtain instruction as regards the regular pension man. Page 72. Page 72.
What was
item
that?
39, 07.
This is 200326 order.
200326. Yes.
Oh.
So they were directed to obtain instruction as regards the regular pension.
page 73.
I have not got you.
No, what has happened? The petitioner has superannuated on 28/2/2020.
Yes.
Thereafter, my lord, there was a
Pension not allowed.
provisional pension I have been receiving, but now the final pension even after 4 years that has not been.
Then
My lord, then we had filed the first petition, that is item 40.
what is the case number?
49, that second case, my lord, item 40.
What is the case number?
4971 of 22.
All right. Then this order was passed.
This order was passed. Then, my lord, during the pendency of that writ petition, they had passed an order on 13/2/2026. That is at page 74. Whereby they said that the first, second, third, fourth, fifth paragraph, my lord, the emoluments received by Bhupendra Nath, last paragraph, my lord, of so and so during the period of suspension will be his entitlement, and he shall not be entitled to any other financial or service benefits for the said suspension period. Consequently, the disciplinary proceeding initiated against Bhupendra Nath stands disposed of. So in fact, but my lord, there was never any disciplinary proceedings, my lord. If my lord may kindly peruse page 52.
So what is the prayer in the petition?
Now that they have to pay the final pension, my lord, that is not. And they were
But I have already communicated, but we get the instruction. I pray for some.
These for the pension department. The main role is of the education department.
Education. Send the proposal. Come to page number 74 in WPC 2074.
70.
Now, in view of this order, last line, second last paragraph, last line you see disciplinary proceedings disposed of. So if it is disposed of, then the pension should be released.
And my lord, if my lord may kindly also see page 70. There was a submission made by them that the pension proposal for release of regular pension and DCRG of the petition has been processed by the respondent authority. Let them apprise this court, my lord, as regards the status. Let them pay the final pension.
Next Wednesday, Lord.
Mr. S. Count, counsel, yes, for the petitioner. Mr. S.M. Chisti, standing counsel, secondary education. Mr. Count submits that in view of the order dated 13 February 2026, passed by the Inspector of Schools, it is clear that the disciplinary proceedings which are stated to have been initiated against the petitioner stand disposed of, which Mr. Count submits that the petitioner disputes that there was any disciplinary proceedings initiated at all. Stop. Be that as it may, since the proceedings have been disposed of, there could be no reason for withholding the final pension of the writ petitioner. Stop. Means at present being granted provisional pension.
Provisional pension.
Mr. SMT.
My pleasure, Your Lordship. Notice on interim was issued, my lord.
For the respondent.
Elementary education. These petitioners are PWD candidates, my lord. They have applied against the advertisement dated 8/1/2025. So for lower primary school and upper primary school, there were two advertisements. One is advertisement A and B. Thereafter, they have applied online. Disability certificates they have annexed in their application, my lord. Thereafter, the physical document verification for the PW candidates were done on 12/11/2025. Next, my lord, on 9/12/2025, medical, they were called for medical examination. Then first provisional merit list was published, second provisional merit list was published, excluding the names of the petitioner.
Yes. Elementary education. In Fukon. He keeps, how many petitioners are there?
Here 7, my lord.
Keep 7 posts vacant if not filled up.
It's not filled up, my lord, because the total advertised post is 4,500 and filled up is 3,515. So 985 is remain vacant.
Heard council. The person with difficult are do you file, but don't fill up these 7 posts for the petitioners till the returnable date. Take instructions. We are giving an interim protection, so you don't fill up. File your affidavit, get your instructions in. But petitioners had offered their candidature for filling up various posts of assistant teachers of lower primary and upper primary schools under the person with disability category in terms of the advertisement dated 8/1/2025 issued by the Director of Elementary Education. Submitted that the cases the petitioners were found, petitioners participated in the selection process and they had also undergone medical examination conducted by the State Medical Board. However, the select list which is impugned dated 10/3/2026, names of the petitioners are not shown. Being aggrieved, the present petition has been filed. The matter was issued on 17/7/26. AMS N. Fukan appears for the elementary education, prays for further time, complete her instructions. The petitioners submit that they belong to persons with disability category and satisfy all the norms. And there are several posts still vacant. And a prayer is made to keep 7 posts vacant in favor of the writ petition. Vacant posts, there are vacant posts available, then 7 vacant posts shall not be filled up without the leave of the court till the next returnable date. The respondents may file their affidavit. In the meantime, pre-list on when do you want it? 7th of September.
Much obliged.
Yes, Mr. Pine.
They have served a copy on the compliance order, madam.
Order appears to have been complied with.
Yes, my lord. One thing, your lordship, this para 3 of the order, if your lordship has. In fact, para 4, madam. My humble submission, my lord, this para is also a contempt to the, my lord, another contempt committed by the.
Which para?
Para 4, my lord.
Read it.
It is observed that recruitment process in question commenced with the advertisement dated so and so, whereas the corrigendum dated so and so was issued subsequent. The said corrigendum does not expressly provide a retrospective operation and therefore cannot be applied retrospectively so as to alter the eligibility conditions governing the recruitment process initiated under the advertisement dated 11/9/2020. This issue was decided by the Honorable Court, and after saying that as because it will operate retrospectively, they were directed to
appoint us,
Where is that?
subject to submit. Your lordship will find it by the page 14, my lord, is the observation, from para 6, page 13 onwards. My lord, the text is here.
Yes.
This clearly said that it will operate retrospective effect. In such if it is in such clarification in nature, my lord, it will affect retrospective. So that on the basis of that only, my lord, the department were directed to appoint us if otherwise eligible. But there, my lord, I'm not on other part, my lord. I'll challenge this order definitely. But my lord, this part, my humble submission, they cannot do it. They have not filed appeal. They have not preferred review. But they are challenging the order of reasonable court by passing this order. This is again a contempt. This is serious, man. Because the issue with the writ petition was that sole ground that was the only ground, man. They did not rejected us for any other ground. That was the ground for which we were rejected. I was rejected. And only to defy this order of reasonable court, my lord, they are doing this. This is done after 4 years of passing of the order. Because the order was passed, my lord, on 23 to 2022. So my humble submission.
The direction of the court is also not specific.
Yes. There were other
You read
connected.
para 4. You read para 4.
Yes. It is submitted by the learned counsel for the petitioner that the government of Assam issued corrigendum dated. This corrigendum was that formal.
Right.
Yes. Assam Gazette removing the requirement of passing the required education qualification before attaining the age of 40 years. Therefore, appointment orders may be issued to the petitioner if they are found to be qualified otherwise. The learned counsel for the petitions also submitted similar cases so and so. The court has directed consideration of appointment of petitioner who are similarly situated. As such, the same relief that was granted in those writ petition may be granted to the present petition. All this, my lord, this was, my lord, accepted by the learned counsel appearing on that, my lord. The learned standing counsel education department fairly submitted that the petitions may be disposed of in which direction to the considered case of the petitioners, keeping in view of the fact and circumstances stated above. In that case, they are found to be qualified otherwise in terms of earlier decided cases. Otherwise, my lord, the other conditions, my lord, I am not on that. Only that aspect. Then it is said, my lord, it is in the aforementioned case, the court has referred the decision rendered by so and so of Supreme Court in so and so, where it has been clearly followed, has been held as full. My lord, this is the para which was relied on. The learned counsel for the appellant is also right in replying upon the decision that court in so and so. This court held it in those cases, my lord, held it clarificatory that a clarificatory notification would take effect retrospective. Such a notification merely clarifies the position and make explicit that what was implicit. Clarificatory notifications have been issued to end the dispute between parties. On the backdrop of the aforesaid decisions, the petitioners are allowed with a direction that the respondent authorities should consider the case of the petitioner for appointment, and based upon the position on merit list, appointment be offered to the petitioner expeditious case. So that was
reading para 4 and 6. We had already pointed out that there is a direction to appoint them.
Yes.
Petition is allowed.
Yes.
Para 7, it says writ petitions are allowed.
Yes.
I do not know what prayer was made in the petition, but it is allowed.
Here, my lord, prayer is that regarding overage.
Prayer was
considered overage.
The issue there was, my lord, they passed that at the age of 40 years. The advertisement said those who have passed at the age of 40 years, they will be not eligible. The advertisement that was removed. That is removed by
The department says it is removed only from the date of corrigendum.
Yes. That is they are now saying, my lord, in this order. But that was taken consideration, and that's why this para, my lord, your lordship, para 14, it said, my lord, page 14. That was this observation was made. As because it is clarificatory in nature, so it should affect retrospective. So even though you remove this, you have to consider them, my lord, on their merit. That was the position then. Now they are saying, my lord, why I'm saying this para 4, my lord, they are saying no, it cannot affect retrospective. That is challenging the direction of this in this order. That's why I'm saying that part is, my lord, that part is again contempt to this. Other, I'm challenging the other parts because they are.
Yes. Regarding this, regarding the order, we have directed to appoint the petition. It is found illegal.
Otherwise,
Here, my lord, in
the merit list.
here, my lord,
Based upon their position in the merit list.
my lord, it's not in the merit list.
That part, my lord, I'm not on that, my lord. If I'm not in the merit list, definitely I will not get it.
You're not in the merit list.
No, I was in the merit list, my lord. That's why I was in the merit list. In the last moment, my lord, when I went there, they did not offer me the appointment letter because of that restriction.
Third, counsel for the parties, the contempt petition is directed against the disobedience, non-compliance of the order dated 23/2/2022, passed in WPC number 113 of 2021 and other connected with petition. By the said order, the coordinate bench directed as under 4567 extract. So, since this order was not complied with, they could file para. After issuance of notice, affidavit is not filed.
Not filed.
Affidavit has not been filed. The respondent counsel has placed an order before the court date 7/8/2026. This order reads as under review. In terms of this order, the petitioner's cases were not considered as their names were not found in the merit list. Such cases where petitioners were not eligible under the applicable recruitment conditions governing the selection process. There are the learned counsel of the petitioner, rather, on the other end, submits that this order is this order clearly reveals that the department has deliberately and willfully violated the directions of the court's order. So, counsel for the respondent on the other end submits that this order has been passed in deference to the directions contained in the order dated so and so, passed in so and so. Being heard, counsel for parties, perusal of the order passed in WPC so and so, dated so and so, as also the order dated 7/8/2026. It is seen that the petitioners had applied for the posts of assistant teacher, Hindi teacher, graduate teacher for primary / lower primary / upper primary / higher secondary schools in various districts. They were allowed to appear in the recruitment process. They were found to be qualified at all levels. However, they were denied appointment on the ground that they did not clear the minimum educational qualification slash TET prior to crossing the upper age limit of 40 years of age. The coordinate bench, while considering the matter, at para 4 of the order held as under para 4 Stecco. And finally, issue the direction at para 7, which reads as under. Reading both the paragraphs, it is clear that the direction was issued to the respondent authorities to appoint, to consider the case of the writ petitioners for appointment based on their position in the merit list. So, there is no dispute that the names of the writ petitioners did not figure in the merit list because of the conditions specified in the advertisement dated so and so. So, there is no clear direction in the order passed by the coordinate bench that the conditions specified in the advertisement regarding minimum education qualification slash STET to have been acquired prior to crossing the upper age limit of 40 years of age. Relied upon by the respondent department while considering the cases of the petition. So, rather, the direction of the court at para 7 is to consider the para 7 of the order dated so and so, that the respondent authority should consider the cases of the petitioners for appointment and based upon their positions in the merit list. Stop. There is no dispute that the names of the writ petitioners did not appear in the merit list.
My lord, I have a dispute in merit list, my lord, their name were appearing.
Huh?
Their name were appearing in the merit. It's not-
Appeared?
Yes. As per my instruction, their name were appearing in the merit list. Only at the final moment, at the time of appointment, they were denied for that purpose, for that reason.
Why can't you give us a clear finding as to whether their names appeared or not? If you don't have the instructions, get it.
Compliance order says they are not selected.
Huh?
Compliance order says they are not selected. That means
That
they are
is
not
what
there.
you are required to comply in terms of the order. Read para 4 and 7 together. You are directed to comply. The writ petitions are allowed. For what purpose?
But para 7 says if their name is in the merit list.
You read para 7, it says petitions are allowed. What is the prayer in the writ petition?
Prayer was
They are not
appointed.
dismissed. The writ petition is not dismissed or disposed of or anything. It is allowed. So the prayers made in the writ petition will have to be accepted to be allowed.
My lord, let's submit one.
The learned counsel for the respondent, counsel for the petitioner on the other end disputes this contention by the respondent counsel that the writ petitioner's name did not appear in the merit list. Under such circumstances, direct the respondents to place before the court position on facts as to whether the names of the writ petitioners appeared in the merit list in pursuance to the advertisement dated so and so by the next date fixed, and thereupon further orders as may be necessary will be passed by the court. It's on 26th.
26th. Public.
Yes. Yes, Mr. Khatoniar, you filed.
Yes, sir.
When did you file it?
It's filed in the month of February, but there was some defect.
February?
Yes, sir. There is
Lying in defect.
there is some defect, Malad, that I have already cleared it with that defect. Now, Malad, there is delay of 139 days. It's trying to find the delay appeal.
Delay for what?
Three days appeal, Malad.
No, no, no. He says some affidavit has been filed in the contempt petition.
No, no.
Appeal.
Appeal.
You file appeal. Heard counsel for the parties. The contempt petition is directed for non-compliance of the directions contained in the order dated 2/9/2025, passed in WPC so and so. The respondents have submitted before the court that they have taken steps to file an appeal against the order dated so and so. However, since there is a delay, steps are also been taken to file an application seeking condonation of the delay. Stop. Para. It has been the consistent view of this court as well as the apex court that filing of appeal or review cannot be a ground for non-compliance of the directions of the court. Until and unless the order which is sought to be complied with, which is required to be complied with by the respondents is new or interfered by an appellate court, the order remains and the respondents are duty bound in law to ensure its compliance within the period fixed. In a recent judgment by the apex court in Israr Ahmed Khan reported in so and so, the apex court had even made it clear that notwithstanding any authority which may not have been the party respondent before the writ court or before the contempt petition, but if it is found that delay in compliance of the order can be attributed to the authority, court may initiate contempt proceedings against this authorities. Stop. Under such circumstances, we permit 1 week further time the respondents to apprise the court as to whether the order has been complied with, failing which the court will proceed to initiate proceedings under the Contempt of Courts Act 1971, read with the Gauhati High Court Contempt of Court. After 1 week, list on 21.
The report conducted by the RT regarding the genuinity of the PhD.
Huh?
Regarding the genuinity of the PhD of the petitioner, so we have filed them, not we are filing today, we have sub the copy to the petitioner as well as the. I find the sub the copy.
You have brought it what? Brought on record?
The inquiry report conducted by the UGC regarding the genuinity of the PhD.
Saying that it is genuine or not genuine?
It's not.
Not genuine.
Yes, they not.
Bring it on record.
Yes.
My lord,
We will not permit you to file reply.
my lord, rejoinder is required very serious.
We'll decide.
My lord, because a serious allegation has been brought on for the first time, my lord, that my lord. My lord, within this
We are
time,
bringing this on record to
my lord,
for your convenience
Yes,
that
yes.
you have some material to of your degree.
my lord, that is
You are
correct.
entitled to challenge it by separate proceeding.
That is correct, my lord, but a short reply will file during this course, my lord, during this date.
We are having it on 12th,
My lord.
at least on 12th August. On the request made by the Mr. A.R. Govildar that a short affidavit has been filed. To bring on record.
We have sub the copy.
It will be filed during the course of the day to bring on record the report respect of the report of the UGC. UGC report.
UGC inquiry report
inquiry report with regard to the genuineness of the PhD degree of the individual. Let this affidavit be placed on record, matter be listed on 12. Mr. A.R. Munia appears for the petitioner, Mr. S. Doctor, Senior Counsel, appears for private respondent so and so. A.R. Munia, Senior Counsel. 12, let us.
Oblige.
Please, Your Lordship. Lordship, we have received the copy of the affidavit of opposition yesterday. We need some time to file the reply.
Filed by who?
Filed by the.
45 tomorrow.
Number 49.
47.
I am for 49, Your Lordship. Item number 40.
47.
47 to 49.
Who has filed the affidavit?
We have filed the affidavit, my lord. My lord, may I pray with regard to 47, things are complete. 48, 49, subject matter is the same.
But you have filed it in 49 yesterday or today.
Yes, my lord. So what I am on, let the fixed date be there because I have been instructed that way that number of teachers, my lord, there are vacancies, my lord, wherein the advertisement has to be taken. Now, in that view of the matter, my lord, let them be given a 1 week time, and by the next week, my lord, can be taken up, my lord, can dispose of this matter. A small question with regard to this has been there, my lord. There was an advertisement in 2024, my lord.
But you will have to. You have filed the affidavit.
Yes, my lord. And you have filed a reply.
Yes.
How much time you want?
2 weeks will be.
I'll leave it to you.
1 week.
The standing council PTC has, or you can say the council for the petitioner in item number 49 submits that an affidavit in opposition has been filed by the respondent council PTC yesterday. Yesterday. He prays for a week's time to file his joinder. Considering the fact that the affidavit was filed yesterday, we permit the prayer of the writ petitioner. Matter be listed after 1 week. Mr. A.K. Bhuiya, Senior Counsel, assisted by Mr. N.R. Sharma, appears for the PTC authorities. M.S. R.B. Bora for 6 in item number 49. Mr. I appears on behalf of ILM. Mr. Sheikh, behalf of ILM. Appearing for respondent number 5 in item 49. That has been listed immediately after 1 month. Right, we give them 2 weeks time. Let us be reasonable.
Yeah.
2 weeks time.
And one clarification, my lord, will be required from the BTC side. With regard to that, my lord, that may be permitted, my lord. By way of an affidavit, we want to bring on record. My lord, additional affidavit will be filing it, my lord, to clarify certain facts.
Mr. Bhuiya also submits that an additional affidavit were to be filed by the behalf of the BTC, which they may be permitted to file, considering you say the matter be listed then on 10th of September.
20 of August, my lord.
20 August, how will you file one additional affidavit, one
By
reply?
Monday, we will file it.
Let it be in September. Give the reasonable time to whatever pleadings you want complete, then we'll hear the matter. Otherwise,
Only thing is that
there is some interim order.
Yes, my lord, in one of the item, my lord, so far 24 advertisement, my lord, 26 order has been passed. That is over altogether. Appointment is over with regard to
You have not filed a vacating petition.
We are preferring it. We are preferring
File it. Or at least the matter immediately after 2 weeks.
Deeply.
There's a lordship with an interim order.
Interim order, wherever passed, will continue to the next date of listing.
Problem.
Deeply.
expired and the legal heirs have filed a substitution petition. But the petitioner in this matter has expired and his legal heirs have filed a substitution, but it has not been numbered. I
Council, IA is not listed.
not numbered yet.
MS as DEB appears for the petitioner, submits that the petitioner is expired during the pendency of the writ petition. However, the right to sue survives. Therefore, the legal heirs have filed an IA, which, however, is not listed today. Submits that the matter be listed after 1 week, along with the IA filed after 1 week. Mr. B.C. Musahari appears for the writ petitioner. Sorry, PTC authority. Yes.
We file our reply by today itself.
Counsel for the petitioner submits that the matter be listed after 1 week as the affidavit in reply will be filed during the course of the day. Prayer made is not objected to by MSD Bora, learned counsel appearing for the respondents. Relist the matter again after 1 week.
This is your lordship here. Your lordship, we have filed our affidavit long time back.
You appear before mediation, sort it out. The parties are directed to appear for mediation before the Gauhati High Court Mediation Center on 21st of August. MS so and so for the petitioner, MS P Das for the respondent. Same order. Unappeals for the petitioner on call. Unappealed. Stop. The parties will appear before the Gauhati High Court Mediation Center on 26th of August. MSP Das for respondents. Unappeals for the petitioner. Want to withdraw. Counsel for the petitioner submits that the writ petitioner does not wish to press the petition any further. Accordingly, writ petition stands dismissed on withdrawal. Interim orders, if any, stand vacated. Pending IAs are also dismissed. And there's to be IPS for respondent. 1 to 6. 7. Yes, who's appearing for the respondents? No, are you filing any objections or not? But it's only for appointment. Why you are objecting? The arbitration clause is there.
Party hereby the case number 19. Parties hereby agree that the control claim or dispute arising in connection with the formal and which cannot be resolved amicably therefore hereby or the executive committee of
File it within 1 week. Let them file their
Please,
objections within 1 week.
Just to respond to my colleague's submission, this is the administrative dispute resolution mechanism. That is not a finality.
Right.
An identical situation had arisen in Karnataka as well, my lord, and the High Court of Honorable High Court of Karnataka has already proceeded and appointed an independent arbitrator. On the last date of hearing, my colleague had handed over those documents. My colleague, so I may be permitted to place additional documents to that effect. She's handing it.
No, this clause number 8, it
Yes.
says arbitration and applicable laws.
An identical situation was there for the same scheme, Deen Dayal Upadhyaya scheme. An identical situation is there for the state of Karnataka as well. This is a administrative resolution process, my lord.
Let them file an objection.
Please, I'm sorry.
The matter.
This is in clause 9, documents that has been handed over to you. Clause 9 of the document so handed. This is the MOU for the state of Karnataka covering the same project and scheme. This is internal page number 10.
But show us from these, where is the arbitration clause?
My lord, this is arbitration and applicable law, clause 9. My lord has it. The parties hereby agree that any controversy, claim, or dispute arising in connection with this MOU and which cannot be resolved amicably shall be referred to the additional Chief Secretary and Development Commissioner, similar situation like us, in the state, whose decision shall be final and binding on all parties.
No, referred to for what? For arbitration.
For arbitration, for the administrative resolution mechanism. So this
So
is
then where is the agreement for referring it to arbitration?
the clause suggests so. Clause 9.
That's what we are trying.
Technically, my lord, in all fairness, this is a defective clause that is appearing even in state of Assam and for state of
Are you saying that there will be a first attempt to resolve these things amicably?
Yes.
And upon its failure, refer to arbitration.
The precondition, precisely, my lord. All that has been
Is it
exhausted.
that or the arbitrator will be that PAC?
All fairness, my lord, I say that there should be an independent arbitrator. All of this is forming a part of the administrative.
Subject to an agreement being there.
But this is a defective clause. That is the reason similar situation was proceeded. In the
There's nothing about order. Merely appoints. Doesn't discuss the effect of the arbitration, the clause. Doesn't say anything. Merely says that an arbitrator is to be appointed.
Because this,
and that too on the basis of a considered opinion of the court.
Yes.
We respect that. There has to be a discussion as to.
Precisely. I understand. But this is a difficulty that even at the first glance I had.
Did you refer these disputes to the PAC?
Yes, my lord.
What
That is all
happened after that?
exhausted. They are still upholding the termination and they are still upholding the recovery.
Where is that order?
Yes,
Page
my lord.
29.
Because this was on a limited footing, same was not annexed. So I may be permitted to bring all of that on record. In fact, they have proceeded to my section 21 notice. I had already apprised my lord in the first instance.
Did they reply anything?
Yes, they have replied by issuing a blacklisting order against me, just because I am asserting my legal right. That blacklisting order is also under challenge before this honorable court.
Where is the 21 notice?
Yes, my lord will have it at page number 24, forming a part of Annexure 3.
So independently, there is no reply to the 21 notice.
No response to 21 notice. They respond by blacklisting me at page number 29. This is exactly 13 days from the date of issuance of my 21 notice.
This order appears to be independent of that. Cannot be construed to be a reply to the 21.
Precisely. I'm just trying to highlight the response of the state.
There is otherwise no response.
No response.
File your objections in 1 week.
Will put us in great difficulty, my lord, in case this particular matter is not referred for arbitration for fair adjudication. End of the, yes.
Let them file their objection.
So obliged.
Mr. N. Das Shan
Shan.
appears for the petitioner, N.S. Appa appears for the respondent. Sole respondent. Application under section 11(6), so we have it. Respondents pray for and are granted a week's time to file their objections. Let the objections be filed, the matter be listed before